We are discussing right now this law of crimes, that is paper 2. The topic is the law of crime, and within this, topic number 1, that is general principle of criminal liability, mens rea and actus reus, mens rea and statutory offences. The second topic is kinds of punishment and emerging trends as to abolition of capital punishment. I hope both 1 and 2 topic you have done. Third topic is preparation and attempt, and fourth is general exception. Now, preparation and attempt is towards the last part of IPC, but we'll take up it sometimes and not right now. This is in section 511, that is general criminal attempt, and this 307, that is attempt to murder. General exception, that is 76 to 106. Joint and constructive liability, this is also in section 34 to 38 and 141 to 149. Abatement 107 to 120, conspiracy is very small topic. Offences against state, basically sedition you have done. So you have done this topic number 9 also. So topic number 1 you have done, 2 you have done, 9 you have done. Rather 8 you have done, not 9. 8, not 9. 9 is very small topic, by the way. So topic number 7, topic number 9 are very small topics. Even 16. A small topic is there, plea bargaining, basically in the domain of CRPC, it is there, we'll let you know, not a very difficult idea. Prevention of Corruption Act and Protection of Civil Rights Act and subsequent legislative enactments are written here, of which certain issues are asked which are in current news, we'll see them. But apart from them, see, joint and constructive liability, that is topic number 5, general exception, that is topic number 4, offense against human body, that is topic number 10, and offense against property. These 4 topics are very important for exam. Topic number 4, 5, 10 and 11. Body, property, joint and constructive liability and general exception. These 4 topics are very, very important. Very, very important. Very, very important. I tell you, it's very, very important. Is this alright? It's very, very important. Now, let us begin with joint and constructive liability, the topic number 5 in your material and the topic number 5 in your syllabus as well. UPC has written topic according to its wish and will, but there are certain concerns in this topic that this should have been written differently, but as they have written it like this, so you can't do much. So let us accept that and let us understand it and let us do our task without going into much discussion whether that is correct or not correct. So why to waste our time there? So chapter 5 of your material, it starts from page 83 of your material. Page 83 of your material. Now see what kind of question is important in this topic, I tell you. See, whenever you study, I tell you, if you want to become an IAS officer, you want to pass this examination, you change the approach of learning. You change the approach of a study. Now when I say that you change the approach of study and you change the approach of learning, I repeat it, it's very, very important. If you want to become an IAS officer, if you want to pass the civil services examination, I can give you a unique idea. And the idea is that you change the method of learning. You should not go by textbook approach, you should go by question paper approach. Now, question paper will tell you what are the key areas of examination. And when you see this, it has static part, it has dynamic part. So now, if I have to read any topic, I'll see the questions carefully so that when I read the text, I can find out the focus area, the islands where the people are there. It is not ocean which we are required to study, it is island where we are required to stand and stay and enjoy and study. What I'm saying, it is islandic study rather than oceanic study. Keep this in mind, it will change the entire discourse of learning. Is this clear, my dear friend? Thank you very much for giving attention to this very statement, which is very, very important. Now, let us come to the topic, joint and constructive liability. Now it says difference between Royd and Affray. Royd is written in 146, Affray is there in 159, I'll tell you. Then it says that difference between section 34. Now see, I'm seeing the question. Again and again you will find a question on this topic. This makes your study very clear. Now section 34, question on section 34. Question on section 149, theory, application both. Then distinguish between common intention, abatement, conspiracy. Then what is the difference between similar and common intention? Now, this is separate question also. Difference is also there. Theory, application on both. Separate questions. Difference is here. All right. Then there is question, application based question. Then the question is on unlawful assembly. What is unlawful assembly? Membership of unlawful assembly. Then again question on section 34. Then I see further question. See, this is very, very important method of learning. Then the difference between common object and common intention. Common object versus common intention. Now, this is the question. This is the question. So, the moment you are seeing the question, you understand the whole periphery of the chapter. The province of the chapter is very clear in your mind. It is crystal clear. And once you do this task, it becomes very easy for you to learn and to grasp the concept very clearly and very swiftly and within short span of time. So you are not required to devote time also, my dear friend. It's very important strategy. Whether you are a law student or not a law student, that doesn't matter for me, because see, it's different concept. So if I tell you without going into nitty-gritties, without going into legality of things and without going into legal terminology, that see, in criminal law, who is generally punished? So you will say that general principle of criminal law is that individual will be held liable for his own acts or criminal acts. All right? Individual will be held liable for his own acts or criminal. Can I be held liable for others' acts generally? No. Nobody will be held liable for others' act. I will not be held liable for your act, and you will not be held liable for my act. It's very simple, genuine, general, reasonable, plausible conclusion, or no, presumption of law, or you can say assumption of law, or you can say proposition of law. I'm not going into the legal meaning of these words. I'm just saying that this is simple proposition of law that every person should be held liable for his own criminal act. Why should he be held liable for others' criminal act? It is not good, it is not ideal. So what I'm saying that you will be held liable for your own criminal act. But then there will be a question that if there is a situation where one person wants to commit crime and he cannot commit crime, but when he is supported by more persons and he acts in combination, he acts in group, he acts in concert, he acts in combination, he acts in group, he acts in concert, that is in combination with others, then he gets or he has courage, he gets confidence to commit the crime. Now, in this situation, will you not punish the others? Again, I think the logic says that he should be or all should be punished. Now, if this is so, then the law says that then all should be held liable. And this is what is the basis behind joint and constructive liability. Joint means the persons are joint, so joint liability, if their actions are joint, their intention is joint, why not their punishment should be joint? Constructive, when for act of one you make others liable, this is what is constructive. This is what is constructive. You construct liability of one on the other. So joint and constructive liability. In this context, I must tell you, we use 3-4 terminologies. So if you are asked a question, what is this doctrine of combination? What do you mean by joint liability? What do you mean by constructive liability? What do you mean by vicarious liability? So the answer of all is same, the same answer. Combination, when people combine. Joint, when they are joint, jointly they are acting, jointly they are planning. Constructive, when we construct liability of one on the other. And vicarious is the same. Vicarious comes from the word vicar. Vicar is a person who acts for another. So suppose on behalf of me, you commit a crime, can I be held liable or not? In such a certain situation, the answer is, depending on the facts and circumstances, the answer will be given. We'll read this in section 34. Section 34 clarifies. Section 149 clarifies that when one will be held liable for the act of another. It is not in all situations that one will be held liable for another. In section 34 and 149, we have clarified the situation when one will be held liable for other. So if you are asked question on any of them, what is doctrine of combination, what is joint liability, what is constructive liability, what is vicarious liability, what is constructive criminality, all this terminology have the same meaning, and the meaning is very, very simple. The meaning is when two or more persons plan jointly and commit crime jointly, then they should be held liable jointly. I said, when two or more persons plan jointly commit crime jointly, then they should be held liable when two or more persons plan jointly and commit crime jointly, then they should be held liable jointly. Plan jointly. commit crime jointly, then they should be held liable jointly. Two or more persons. Plan jointly and commit crime jointly, then they should be held liable jointly. That is very simple assertion, that is very simple general principle. Two or more persons plan jointly and commit crime jointly, then they should be held liable jointly. Now on this point, now if you want to write better answer, you can quote further. See, in your material also I have written this under English law and Indian law. We are not required to read that, that is not useful. You read one of the most prolific author on criminal law, that is Professor Kenny. Kenny says, one of the main purpose of law is to discourage tumultuous assemblage of men. One of the main purpose of law is to discourage tumultuous assemblage of men. So, if law thinks that there is an assemblage which is tumultuous, which can cause devastation, which can create devastation, which can cause destruction, then why it should not be prohibited? Why it should not be prevented? This is not today's principle. This has been principle of yore also. Yore means Y-O-R, yore means past. This has been principle in the past as well. That why not to prohibit and prevent it in the very early stage? Nip it in the bud. Now, prevent it in the very early stage. That is why I see the law has a mechanism. When you become an officer, my dear friend, I tell you, you will come across provision in CRPC also, Criminal Procedure Court. You have to read law when you become officer, because administration can never be run without law. Whatever officer you become, you are required to see CRPC, you are required to see CPC, you are required to study law, you are required to know IPC. This is mandatory. You may not be required to now read other subjects, use other, but law is very much utility subject. You will have to see the provision of law. You can't run your administration without law, being it DM, being it SP, being it now IRS officer. You can't run your administration without law. Law is very important subject for that matter, but it is upon the world to understand, not on me to make them understand, because I have been trying it very hard, but people generally do not understand. That's their take. So let us come to the point. I said that now there are mechanisms. So I tell you, in CRPC also section 129 says that if there is any assembly where the people are there, maybe 3, 4, 5, 6, 7, 8, 9, 10, assembly of people are there, which has the tendency. So in India, we have at least 5 people for assembly. So if there are 5 or more people who have tendency to become unlawful, then the magistrate has power to prevent them. This is CRPC. In IPC, it says that if you have committed crime, then you will be punished for it. See, CRPC provides for preventive mechanism, IPC provides for punitive mechanism. In CRPC also it is written that if there is any assembly which has tendency to become unlawful, then magistrate has power to prevent it. We are not reading CRPC right now, so I am not going into that domain. But in our IPC, which we will be studying here right now, now if any unlawful assembly, if any member of unlawful assembly does any crime, then you will punish him. So in IPC as well, section 141 to 160 basically prescribes various provisions or situations where where a member of unlawful assembly can be punished. For example, Section 149 is one such provision. There are other provisions also. Similarly, in Section 34, if there are two or more persons who similarly in Section 34, if there are two or more persons who have common intention, they should have common intention. I'll tell you what is this common intention. Who have common intention to commit a criminal act, then each one of them will be held liable for all acts. For all acts, I'm saying, for all acts. Every one of them will be held liable for all acts. Liability is same or similar. Liability is same or similar. So basically, when we are discussing joint liability or constructive criminality or doctrine of combination, this is the principle, this is the provision which we are required to concentrate on. So let us take them one by one. So first we are taking this section 34. First we are taking this section 34. Now, just to study this section 34, if you read section 34, see there are many facts written in your material, but I will tell you only those facts which are very important for your examination and which are necessary for you to know. There are other things written in your material which is written just for the purpose of information, and those who are interested in studying further, they can see and they can learn better. So nothing wrong in it, you can learn better if you see that, but I'll tell you complete thing in the class itself, you should not worry at all. All your men's question will be answered on the basis of what I am talking in the class. You are not required to go anywhere. You are not required to look beyond the class. Be ready and willing to learn in the class, and that is full and final. So what section 34 says, in my words, I tell you, if a criminal act is done by several persons in furtherance of common intention of all, then each one of them is held liable as if all acts are done by him alone. So what it says, if a criminal act is done, see, if you keep in mind the bare provision, if a criminal act is done by several persons, so it is not required to be memorized, you should not. But if you read it time, if a criminal act is done by several persons, then in furtherance of common intention, in furtherance of common intention, then each one of them, is held liable as if it was, as if it was done by, as if it were done by him alone. Now what it says, if a criminal act is done by whom? By several means more than one. Several means more than one. In furtherance of common intention, then what will be the consequence? Each one of them is held liable as if it were done by him alone. So each one of them will be held liable as if all acts have been done by him alone. So you are not required to worry at all. If a criminal act is done by several persons in furtherance of common intention of all, you write here common intention of all. Then each one of common intention of all, then each one of them is held liable as if it were done by him alone. If a criminal act is done by several persons in furtherance of common intention of all, then each one of them is held liable as if it were done by him alone. So now what are the requirements of section 34 to be satisfied before you bring a person in section 34? I explain it one by one. Essential conditions for invocation of section 34. I think that anybody who has never read law, even he or she can understand this. Essential condition for invocation, that is application of section 34. First, criminal act should be done. So there is a criminal act. Criminal act should be done. Then second, it should be done by several persons. It should be done by several persons. That is two or more. Third, criminal act should be done by several persons. Third, if a criminal act is done by several persons in furtherance of, it should be done in furtherance of common intention of all. Then consequence, if these three conditions are satisfied, then the consequence follows, and consequence is then every one of them will be held liable as if all acts were done by him alone. So every person involved in the crime will be held liable in the same manner. So first point does not require any clarification. I am very clear, criminal act should be done. So some crime is committed, that is enough. That is enough. Criminal act is done in furtherance of common intention of all. Now, a question may be in your mind that a criminal act is there, but we plan to do criminal act acts, and unfortunately criminal act Y is done. We wanted to do acts. Now suppose I am raising a question. X, Y, Z are three persons who planned to commit murder of A. Planned to commit murder of A. Now they happen to commit murder of B, mistaking for A. Mistaking for A. Now can they be held liable or not? Criminal act is done or not? Is it in furtherance of common intention or not? Yes, it is. Criminal act is done. Criminal act is done in furtherance of common intention. So some criminal act should have been done. Either it should be murder, or it should be rape, or it should be theft, whatever. There are various criminal acts which you have never studied, so we will study. If you have studied, well and good, you know everything. There are crimes, there are various crimes in IPC. I have told you already that there are various interests which have been being protected by state, interest of army, navy, air force, interest of the whole society in public order. So interest of law and justice, offences against public servant. Now all these are different interests, interest in our body, interest in our property. So these are different offences. These are different kind of crimes. So criminal act should be done, number one. Number two, it should be done by several persons. Now I tell you, now several person should be, two or more persons at least. So section 34 requires, you can write down one by one, section 34 requires two or more persons. Section 34 requires participation of two or more persons in commission of crime, in criminal act. Now these two persons must be competent persons. It cannot be that one is competent, another one is must be competent person. Must be competent person. Must be competent person. Is this all right? Must be competent person. So it cannot be that one is competent, another one is incompetent, so section 34 can be. Section 34 requires at least two competent persons. At least two competent persons. Yes. Yes. Must be competent persons. Must be competent persons. All right. All right. It cannot be that one is competent and another one is incompetent, so two persons are there. No. At least two competent persons are required. And then, now, like you will read in partnership that at least two competent persons are required. There can be third incompetent, no problem. But at least two competent person is a necessity of law. So section 34 requires participation of two or more persons in criminal act. Now, what does this participation means? Now, I must tell you, participation means that the persons involved must be participating in criminal act, must be participating in criminal act either by presence or absence or by either by presence or absence either by presence or absence or by distant direction or by participation in actual criminal act at the site. It can be different kind of participation. See, it is not always necessary that you should be physically present. In other words, physical presence is not necessary. In other words, physical presence is not necessary. In other words, physical presence is not necessary. Physical presence is not necessary in all crimes or cases. It can be done even by not being there. I tell you, physical presence is not necessary in all crimes or cases. Physical presence is not necessary in all crimes and cases. So I was talking of this participation. I said that there should be participation, but participation does not mean physical presence. You should be very clear about the point that participation does not mean physical presence. Now, I tell you, there are two kind of cases. There are two kind of cases. Cases involving physical violence versus cases not involving physical violence. Cases not involving physical violence. Not involving physical violence. Now, the cases involving physical violence will necessitate physical presence, because without physical presence, how can you cause physical violence? This is very commonsensical. I am teaching in very simple language. Cases not involving physical violence does not require physical presence. Does not require physical presence. Does not require physical presence. Does not require it. Try to understand this. For example, if I say that somebody has committed murder or committed rape, then if he is to be brought within section 34, physical presence is must. But if I say that somebody committed criminal breach of trust is an offense relating to property. Murder and rape is related to body, where violence is necessary, where force is required. In that case, physical presence is must. But in case of criminal breach of trust or cheating for that matter, physical presence is not at all required. Who will say that cheating can be done only when I am standing there? Cheating can be done from faraway places. A person sitting in Dubai can cheat a person in India. A person sitting in Mumbai can cheat a person in Bangalore. So, it cannot be said that it requires physical presence. So, cases not involving physical violence does not require physical presence. But where physical violence is a necessity, how can you cause physical violence without being present? Tell me. So, in case of murder, in case of rape, etc., physical presence is necessary. But not in case of cheating, not in case of criminal breach of trust. Criminal breach of trust is something similar to that. I'll tell you, criminal breach of trust, where you have entrusted some property to somebody and then he dishonestly now disposes the property or uses that property, so that is criminal breach. You entrusted property for safe custody to somebody and now he disposed that property, he sold it or he used it in some other way which was not permitted. So that is what is criminal breach of trust. I'll tell you a little later, not here right now. So physical presence is necessary in offences involving physical violence, but not so in cases not involving physical violence like cheating or CBT. This is common sense. Now, so presence is must, but presence is not. Participation is must. So I submit participation is must. But presence is not. This can be a beautiful question also. This is what is the depth you are required to create in your understanding, and that is how you can pass the examination very easily. It's not a difficult examination, it is just a question of approach. Any subject can do wonders if you have the approach, right approach. If you make it technical, legal, then it will not prove beneficial. It should be read very simply, logically, now very easily. I quote a case here. Now, what do you mean by presence? Presence means now, what is presence? Now, then there is another question. What is presence there? Or what is participation in other words? There is a question. Let us say this. What is participation? What is presence? So, answer is What is presence or what is participation? I tell you what is presence and what is participation. There is a case Barendra Kumar Ghosh versus King Emperor. This is a very old case decided eh, at the time when India was not independent. India was ruled by British people. Barendra Kumar Ghosh versus. You are not required to memorize name of cases, not at all. I don't recommend it. If you remember it, it is well and good. If you do not, AIR 1925, Privy Council, page 1. I remember the citation. Are you required to remember the citation? Not at all. It will be now waste of your time and energy. You just remember that there was a case I read somewhere, BK Ghosh. Even if you don't remember, you write the principle. Then what is presence? What is participation? So what Barendra Kumar Ghosh says, I tell you. What Barendra Kumar Ghosh says. What Barendra Kumar Ghosh versus King Emperor says, I tell you. Now it tells you the point, Barendra Kumar Ghosh versus King Emperor. Let's see, in this case what happens, I tell you little bit facts. And it is written in your material because see, you can't write the entire case in your examination, never ever. Can you look into page 85 of your material? Those who have, it's well and good. Then those who do not have material, they should listen to me. This is on page 85 of your material of this IPC of IS batch. It says in this case, several persons appeared at the door of the room where postmaster was counting the money and they demanded the money. So many people go to his place and demand money. He is the postmaster. Many people visit the post office and they demand money. They tell him that you please give me money now, and that is how you can be spared. But he does not part with the money. Now then, few people have entered into the post office, and Barendra Kumar Ghosh was posted outside. He was required to stand outside as a guard. So he is standing outside as a guard. Few of his friends entered into the post office and they demanded money. Money was not given to them, so they fired upon the postmaster. Postmaster died. So the persons who were inside the post office who killed the postmaster, they will be held liable. Now the question was that Barendra Kumar Ghosh, who was standing outside as a guard, can he be held liable or not? This is the question. So question is that was he participating in this criminal act or not? Because it is offences involving physical violence. Now see, you must understand and you must apply your common sense and logic, and you must understand that if somebody is committing crime in my classroom, and his friend is standing outside the classroom just to intimate him whether the police is coming or whether somebody is coming or whether there is some kind of danger, is it not help in committing the crime? The answer is obviously yes. It's a big help so that you can commit crime inside the room very easily. So Barendra Kumar Ghosh, who was standing outside as a guard, he is a big help for the people committing crime inside. So he is participating in the crime. So in Barendra Kumar Ghosh versus King Emperor, I will not write the whole facts that the people went to commit robbery in a post office and post office was situated in Sankari Tola. It is not required to be written in your examination. You are going to be officers. You must write like officer, that you write the crux, the conclusion of the point. So I will write, even when BK Ghosh, even if I do not remember the name, I'll write, even when the accused means one who has been accused, when one against whom there is accusation of crime, accusation. So even when BK Ghosh, who was standing outside, and this is all common sense, who was standing outside the post office as a watch to guard against any unforeseen unforeseen danger. When BK Ghosh was standing outside the post office as a watch to guard against any unforeseen danger, he was considered to have participated in the crime. He was considered to have participated in the crime. Even Macmillan, the poet, the great poet, in his uh, uh, that creation that is on his blindness, he said, "Those who stand, wait, and watch, they also participate. Those who stand, wait, and watch, they also participate." If you are standing, waiting, you are also criminal. You are also doing the crime. Those who stand, wait, and watch. Now you go to temple and you watch in long queue, and you may not be allowed to have that divine view of the God. Are you not worshipping the God? Yes, you are. You will be getting the desired result. You will become an IAS officer. So Barendra Kumar Ghosh, who was standing outside the post office as a watch to guard against any unforeseen danger, then he was considered to have participated in the crime, even though he was not within the room of the crime, even though he was not within the room where the crime was committed. This is very, very important point to be kept in mind, that those who stand, wait, and watch, and it is not necessary always that you should be participating in the crime by entering into the room where the crime is being committed. It says further, if you see carefully, now the law further says, he also argued that, see, I was just standing outside, I did not participate in the crime. Court said this is also a kind of participation, my dear friend. If you are standing as a watch and you are guarding him against any unforeseen danger, so what you are doing? You are helping him in the commission of crime. So how are you not participating? You are obviously participating. That is why I say law is common sense and logic. It doesn't require any kind of special knowledge. It's very simple. Now, section 34 deals with the doing of several or similar or diverse act by several persons, but all should be done in furtherance of common intention. All right, this is perfectly all right. Now, on the other hand, offences not involving physical violence, offences not involving physical violence, offences not involving physical violence. Now, this is the case J.M. Desai versus J.M. Desai versus State of Bombay. At that time, it was the State of Bombay. State of Bombay. J.M. Desai versus State of Bombay. J.M. Desai versus State of Bombay. In this case, there was an MD, an expert of cloth dyeing company. They entered into a contract with textile commissioner for dyeing of the clothes. They, however, did not deliver back certain clothes to the commissioner in spite of repeated requests. Ultimately, both the appellants were prosecuted under section 409, that is criminal breach of trust, read with section 34. So, A, MD and B expert of the cloth dyeing company entered into contract with textile commissioner. So, two persons, that is MD and expert, I'm not concerned with their name and their designation, and expert of dyeing, cloth dyeing, 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 cloth dyeing. So, managing director and cloth dyer, entered into contract, had a contract with the commissioner of dyeing the cloth, but did not return cloth after dyeing. But did not return cloth after dyeing. Ultimately, they were prosecuted under Section 409. And the argument was advanced that when the crime was committed, he was not present at the scene of crime. This was the argument. You will read another case also. They said that we cannot be prosecuted on the basis of Section 34. They were prosecuted under Section 409 read with 34. So their objection is on 34. 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 Is this clear? So now they say that we cannot be held liable on the basis of Section 34 because we were not present at the scene of crime. So question arose whether presence at the scene of crime is necessary. Court said in that crime like criminal breach of trust, where property has been entrusted to one which has been, now where the trust has been breached, what is the use of presence? Tell me. There is no use of presence in breach of trust. Only thing enough is that there is trust and it has been breached. And it has been breached criminally, it means it has been done with wrong intention. So nothing beyond this is required. Nothing beyond this is required. So my presence is required. Court said, I have written a lot, but you are not required. Just cite that court said that in offence like CBT, presence does not matter at all. Presence does not matter at all. What to do with presence? What to do with presence? What the presence will do? You see, even in case of Tukaram versus State of Maharashtra, you read these cases, it is written in your material. Tukaram versus State of Maharashtra. Tukaram versus State of Maharashtra. Just look into these cases versus State of Maharashtra. Again, the same thing is reiterated. The facts are there. If you want to read it further for your interest, it's beautiful. EIR means All India Reporter. 1979 is the year when it was reported. SC means Supreme Court, 185, page 185. So, if you go to volume of Supreme Court AIR in 1979, you will find this case on page 185. You pick AIR of 1979, see Supreme Court cases are there, page 185 you will get this. This is the value of this citation. Accused broke down the godown of a company, removed some copper wire bundles by a truck. The truck was stopped at a nearby weighbridge where the brokers were present to negotiate the sale of copper wire. So copper wire is taken from godown from one place. It is being loaded in the truck and then truck is taken to weighbridge, and at weighbridge certain more people are there to get the deal done. The appellant, one co-accused, was present at the weighbridge. One person was present at the weighbridge, but not at the scene of occurrence where the copper wire was taken. The appellant was held guilty, however, on the ground that he supplied the duplicate key of go down and waited at the weighbridge. So see, this is very, very important that one person who was not, I'll write in my language, who was not present at the scene of crime but was found at the place where goods were to be disposed of. One person who was not present at the scene of crime but was found at the place where goods were to be disposed of was held liable on the ground that he supplied duplicate key. He supplied duplicate key for removal of goods. So his involvement is also there. And waited at weighbridge. So involvement is there. So is it necessary that he should be present at the place where the goods have been removed? It is not required. Even it is not required. Even if it is a case of stealing, that is theft. Stealing, chori, theft. Theft is stealing. So court said it is not required. It is not required. One person who was not present at the scene of crime but was found at the place where goods were to be disposed of was held liable on the ground that he supplied duplicate key for removal of goods and waited at the weighbridge. Waited at the weighbridge. So his involvement is ensured. His presence is not there. His presence is not there. His involvement is there. His presence is not there. One person who was not present at the scene of crime but was found at the place where goods were to be disposed of as was held liable on the ground that he supplied duplicate key for removal of goods and waited at weighbridge. Alright, waited at weighbridge. So always physical presence is not required. Now, especially on in those cases where violence is not necessary, participation by physical presence is not required. It can be by distant direction also. See, in a crime you are participating and you can always instruct from some place, nearby place. This is also enough. It is not necessary at all time that there should be participation in the crime by being physically present there. Mehboob Shah versus Emperor. Now there is another case, this is not exactly on that point. So I think that you have covered this. There should be a criminal act. The criminal act should be done by two or more persons. Criminal act done by two or more. Now suppose there is not more than, not two or more. So then question arises, can one be held liable? Can one be held liable under section 34? Then there is another question. Can a person be held liable for section 34 only without invoking any other section? I tell you, for all those who read law, those who have read law, then they are aware those who are studying for the first time, I inform them even. That in criminal law in IPC, if you commit a crime, then you will be held liable for that particular crime. Like suppose if I have committed murder, I will be charged under section 302. Now see, charging section in criminal law is punishing section. Murder is defined in section 300, but it is charged under section 302. 302 is punishment for murder. So there may be a definitional section, there may be a punishing section. You do not charge anybody per definition under definitional section. You charge a person under punishing section. So you will always charge. See, like theft is defined in 378, but it is punishable in 379, 80, 81 and 82, something like that. So you will charge a person in 379 or 380 or 381 or 382, not in 378, which is definitional section. So what I want to say that if a person has to be charged for a particular crime, then if he has committed murder, 302 will be invoked. If he has committed theft, no, then 379 will be invoked, something like that. Can you invoke section 34 alone against a person? The answer is no. Because section 34 does not create a crime. It is not theft. It is not murder. It is no crime at all. So why we are talking of section 34? Section 34 only says that see, if one person commits crime, then one person commits murder, then he will be charged under section 302. If two or more person commit crime and his case falls in section 34, that is two or more person committing crime in furtherance of common intention. Crime can be any crime. So if it is murder committed by two or more, then he will be charged under section 302 read with 34. So the moment when two or more comes, 34 comes. 34 does not define a criminal act. 34 does not create a specific offense. 34 only says that when there are two or more, then 34 will be invoked. So can a person be held liable or charged under section 34 only without invoking any section? The answer is no. This question has no answer. It can always be invoked. It can always be invoked along with a substantive section like section 302 or section 379. Can a person be held liable for section 34 only without invoking any other section? The answer is no. It can always be invoked along with a substantive section like section 302 or section 379. Can a person be held liable under section 34? Can one person be held liable? You said if a criminal act is done by two or more, can a person held liable? Can single person be held liable under section 34? That is the question. See, generally answering the question no, no, no. The answer is one person cannot be held liable for section 34 as it always requires participation of two or more persons at a list. But if it is proved that two or more committed crime, it is proved that two or more committed crime, but one only is found or caught, then it can be invoked against that one as well. So see, what I am focusing on, whether there is participation of two or more. If participation of two or more is there, then you can invoke section 34 even against one person. For example, suppose A and B committed crime. A runs away to a foreign country and not caught and not obtained by India. Can B be charged under section 34 or not? The answer is yes, because it is shown that A and B have committed crime. So even participation of two or more is proved, then one alone can be charged under section 34. But if it is the fact that only one is there, second one is not there, then you cannot invoke section 34. No, 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 no. You cannot do it. One alone cannot be held liable. One alone cannot be held liable. You cannot charge one under section 34. You cannot charge one under section 34. If it is that two or more have participated in the criminal act, and then one can be held liable, one can be charged. If one has run away, now there may be many situations. Suppose A and B committed crime and B died. Only A is caught. Now, can A be booked under 34? Yes. A and B have committed crime and A runs away. Can B alone be charged under section 34? Yes. Because it is proven that A and B both participated in the crime. So, what we are required to show to the court that two or more persons participated in the crime, whoever is caught, he will be held liable or he will be charged under section 34. This is what is section 34. Now, then the next question comes up in your mind. Criminal act is done, it is done by several persons, then it says it should be done in furtherance of common intention. Now, question is, what do you mean by expression in furtherance of common intention of all? First question is, what is common intention? What do you mean by expression in furtherance of common intention of all? What do you mean by expression in furtherance of common intention of all? So I tell you, common intention means prior concert, pre-arranged plan, prior meeting of mind, prior concert, pre-arranged plan, prior meeting of mind, so you can write down very simply, common intention means prior meeting of mind. Common intention means prior meeting of mind, prior meeting. You met, your mind met earlier, prior meeting of mind or pre-arranged plan Common intention means prior meeting of mind or pre-arranged plan. It contemplates It contemplates knowledge and sharing. It contemplates knowledge and sharing of each other's intention. Each other's intention. It requires it requires meeting of mind. It requires meeting of mind of all concerned. Common intention means prior meeting of mind or pre-general plan. It contemplates knowledge and sharing of each other's intention. It requires meeting of mind of all concerned before commission of crime. It requires meeting of mind of all concerned before commission of crime. So common intention, I hope you understand, unless and until the minds of the person concerned meet, it cannot be common intention. Suppose, here comes the question, what is the difference between common intention and similar intention? See, A and B, you can write down this example also. In this context, for proper understanding of common intention, one can differentiate between common intention and similar intention or same intention. Similar intention or same intention. For proper understanding of common intention, for proper understanding of common intention, one can understand, oh, one can for proper understanding of common intention, one can see the difference between common intention and same or similar intention. Same or similar intention. For proper understanding of common intention, one can see the difference between common intention and same or similar intention. And for this purpose, we can understand or we can look into Mehboob Shah case. We can look into Mehboob Shah case. So, for proper understanding of common intention, one can see the difference between common intention and same or similar intention. This is clarified in case of Mehboob Shah. Mehboob Shah versus King Emperor. Mehboob Shah versus King Emperor. Now, in Mehboob Shah versus King Emperor, if you see the facts, you will find many names and you will be confused. So, this is not the way how to study the cases. For our purpose, for IS examination, I am very clear in my mind that you are required to understand the principle. But for understanding of principle, you can look into the facts sometimes. So, what facts are relevant and how it is to be read, that is what I will tell you right now. so that you can understand how the facts have to be read. Now see, Mahbub Shah versus King Emperor is a case written in your material, page 85, and what it says that there is a person along with few others went to cut and collect reed on the bank of river Indus. So they have gone to collect and cut reeds. There is wood for cooking food, basically, that is used for cooking food uh, from the land belonging to another person called Muhammad Shah, father of Wali Shah. So you are not required to remember the names. Don't do it, for God's sake. Allah, in spite of repeated warnings, he continued to collect and cut the reeds and to collect the reeds and take it away. And on this, there was a fight which ensued between them. And then, just to save Allah, two persons came from two directions and they fired on opposite party. So, main question is that two persons came from two different directions to save the victim. All right. And both of them, see how I changed the facts and I wrote the crux, both of them fired gunshots against opposite party, against opposite party, two persons came from two different directions to save the victim and both of them fired gunshots against opposite parties. Against opposite parties. Out of which bullet of one hit one person and injured him. And bullet of another, so it is fired by another person. Bullet of another killed one of them. Now question arose, can both of them be held liable? 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 That is the question. Can both of them be held liable? This is the question. Can both of them be held liable? Both of them can be held liable for murder of one. See, another killed. So, basic question in this case is, I must explain even further, that whether for this killing both of them can be held liable. Now, two persons came from two different directions. One fired gunshot which has hit and grievously injured one person. Another fired gunshot and it killed somebody. Now the question is, now the person who has killed, he will be held liable for killing. That is clear. Whether the other person will be held liable for this killing or not, that is the question. And I tell you very interestingly, the person who killed him, he ran away and he fled to Pakistan or something like that. He could not be caught. The other person is caught, and now prosecution is trying to put him to apply against him section 302 read with 34. So this is the question. Can we invoke section 302 read with 34 against that person whose gunshot did not result in death of the person concerned? This is the question. So it can be done only on the basis of section 34. So question is that can we invoke section 34 against that person who has come from different direction and where there was no common intention? So this is the question. To answer it, we have to see whether the person whose gunshot did not result in killing, that is death, can be brought within province of section 34. If yes, then he can be held liable. He can be held liable If yes, then he can be held liable under section 302 read with section 34. He can be held liable under section 302 read with section 34. He can be held liable under section 302 read with 34. Is this clear? Is this all right? Did you appreciate the fact? Yes. Okay. So now we are required to see, and to invoke section 34, we need to show common intention. Basically, we are required to show whether there is common intention or not. We need to show that whether there is common intention or not. We need to see whether there is common intention or not. That is the basic question. That is the basic question. And to invoke section 34, we need to show common intention. We need to show common intention. Is this clear? We need to show common intention. To invoke section 34, we need to show common intention. And common intention requires prior meeting of mind. or prior concert. Prior meeting of mind or prior concert or pre-arranged plan or pre-arranged plan. Can we see prior concert of prior meeting of mind or prior concert or pre-arranged plan in this case? Can we see this? The answer is no. The answer is no. We cannot see this. How can there be prior concert? How can there be prior meeting? They came from different direction. They came from different direction. And they did not meet. And there was no prior meeting or pre-arranged plan. There was no prior meeting or pre-arranged plan. There was no prior meeting or pre-arranged plan. They came from different directions. They did not meet. There was no prior meeting. There was no prior meeting or pre-arranged plan. Common intention requires prior meeting of mind, prior concert, pre-arranged plan. They came from different direction and they did not meet. And there was see, they came from different. They both were on hunting. They have gone for hunting. They are in different directions. They just heard the cry of the person concerned and they came to rescue him. So till this point, they have same intention. Their intention was to rescue the person, and for this purpose, they fired the gunshots. Both of them fired the gunshot on opposite party. So till this time their intention is same. But will it be common? Common when there will be exchange of idea, when there will be exchange of idea, knowledge and sharing of each other. You say to me what is your intention and I say to you what is my intention, then your intention, my intention which was same or similar earlier will become common. So to make it common, there has to be exchange of intention. There has to be knowledge and sharing of each other's idea. Unless and until it happens, there is no common intention. There is no common intention. There is no common intention. It has to be shared. There has to be exchange of idea. Now, this exchange of idea can be at the spur of moment also. That is called eo instanti. Is at the spur of moment. Immediately. Eo instanti, there can be exchange of idea. But was there anything like that in between? There is no fact which suggests that they exchange the idea. Exchange of idea can be in the words that one said beat him, another said beat him. Now both said let us beat him. This is exchange of idea. Enough. Common intention is developed at this spot. Eo instanti. Common intention develops at this spot. That is called eo instanti. But was there any kind of common intention eo instanti? No. 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 In Mahbubsa versus King Emperor, there was no common intention which developed at this spot. There was no eo instanti common intention, so it is not there. It is not there. It is not there. No eo instanti common intention. No eo instanti common intention. When it is not so, can common intention be said there? Though there is no common intention. See, I have written in your material also on page 86 common intention versus similar or same intention. Now, the line which divides the common intention from same or similar intention is very thin. But nevertheless, the distinction is real and substantial. To constitute common intention, it is necessary that intention of each person should be known to the other. There should be exchange, whereas this is not so in case of same. So, common intention requires exchange or sharing of intention. But same or similar intention does not require this. I have the same intention to kill A, you have the same intention to kill B, but we did not talk. So can it be common? No, it is same or similar. Does not require it, does not require it. Now see, even in Pandurang birth state of Hyderabad, Pandurang birth state of Hyderabad, written in your material, state of Hyderabad, AIR 1955, Supreme Court 216. Pandurang versus State of Hyderabad. Pandurang versus State of Hyderabad. Now in this case, the court said several persons can simultaneously attack, several persons can simultaneously attack a man, and each one can have the intention, namely intention to kill. I am quoting this, namely intention to kill, and each can inflict a separate fatal blow, and yet none would have yet none would have the common intention, yet none would have the common intention required by yet none would have the common intention required by specific person, required by specific section, required by specific section, then common intention required by specific section because there was no prior meeting of, because there was no prior meeting of mind to form a pre-arranged plan. To form a pre-arranged plan. So this is what is. In a case like that, it would be individually. So each will be individually liable. Each will be individually liable. So it will be individually liable, but none will be vicariously liable. So you cannot be held liable for others' act, vicariously liable. No, 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 vicarious liability is not there. Is not there. In many cases, it may happen. Now, you may ask the question, why this kind of section 34? It says if a criminal act is done by several persons in furtherance of common intention of all, then each one of them is held liable. So, furtherance of common intention you must. If the act is not in furtherance of common intention, then you cannot be held liable. Now, suppose, now three of us went to commit murder of somebody. Commit murder of somebody. Now, in committing murder of that person, his PSO comes, personal security officer comes, PSO, and he does not allow you to kill him. He comes in front of him and you kill him. It is in furtherance of common intention. It is in furtherance. It furthers your criminal design, your desire. But suppose you kill their children playing innocently outside the house. Is it in furtherance of common intention? Tell me. Just to teach that person lesson. In one case it happened that few criminals came to murder somebody. He ran away inside his house, frustrated, agitated. The criminals could not kill him, so they killed his children playing outside his house, frustrated, agitated, annoyed. Now, is it in furtherance of common intention? The answer is no. The answer is no. It is not in furtherance of common intention. Furtherance of common intention does not mean this. Furtherance of common intention means that you have committed a crime where the crime is committed now to further the criminal design, further the criminal act, further the criminal act, further the criminal design. Is this all right? Is this all right? Otherwise, it will not come within that. Rishidev Pandey, common intention may develop on the spot. I already said, you is instantly. You're not required to remember the cases, but you can see. Common intention may develop on the spot. This is on page 87. Is Pandurangbar state of Hyderabad. I have already read that paragraph, which is important, same and similar intention. Same and similar intention. Same or similar intention. Now Hathuba versus state, you can see, waiting for the enemy to come by bullock. They attacked the first bullock cart which had not been occupied by the enemy but someone else. Supreme Court holding all of them liable. So, if you mistakenly kill somebody else, you wanted to kill A and you killed B, even then you will be held liable. Even then you will be held liable. You wanted to kill A, it is in furtherance of common intention. Furtherance of common intention. Furtherance. What is in furtherance of common intention? Question is, what is in furtherance of common intention? The answer is killing innocent person under mistaken belief that he is the desired, he is the desired target, is in furtherance of common intention. Killing innocent person under mistaken belief that he is the desired target is in furtherance of common intention. Furthermore, killing innocent person under mistaken belief that he is the desired target is in furtherance of common intention. Furthermore, I said killing innocent children playing outside house where the person targeted runs away, runs inside house. Innocent children of whom? Of this person, of person targeted, runs inside house is not in furtherance. Is not in furtherance of common intention. But killing PSO who comes in between and he saves his master is again in furtherance of common intention. It is 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 in furtherance of common intention. Rest of them you can read and you can, if you have any issue, you can contact me again, you can ask me again, not an issue. So if a criminal act is done by several persons in furtherance of common intention of all, then each one of them is held liable for the act in the same manner as if all acts were done by him alone. So see, the liability of all acts are shifted to one. Liability of all acts are shifted to one. So even if one is caught, where it is proved that the criminal act is done by several persons, then liability can be imposed on one person. Liability can be imposed on one person. So related to section 34, there is information in your material also that section 34 has been amended just to differentiate section 34 from 149, and has been written in furtherance of common intention of all, which was not there earlier. It has been amended and then it has been inserted. So you can see this is written in 1870. They added this word in furtherance of common intention of all. It was not earlier there. So common intention should be there. The act should be done in furtherance of common intention. It should be by several persons. Presence is not required always. Physical presence is not required always. It is participation which is necessary, not the presence. It is participation which is necessary, not the presence. The difference between common intention versus similar intention has been made clear to you, my dear friends. So I hope we have covered all the points of section 34. Section 34, it can develop even eo instanti, but it should develop just before the crime has been committed. If it is not developed before the crime is committed, then there is difficulty, then there will be no liability, Prior meeting of mind is must for this section 34 invocation. Section 34 invocation, prior meeting of mind is very, very important. I was just reading this recent judgment. Krishna Murthy and others versus State of Karnataka, criminal appeal number 288 of 2022. This is not reported yet, so I cannot give you citation. Krishna Murthy, this is, and others versus state of, in criminal law it is always versus state of Karnataka, because state is a party in criminal law. State prosecutes, punishes. Krishna Murthy and others versus state of Karnataka. The man accused in the case, along with his two aides, were holding the hands of the deceased and beating with hands and legs. After a while, the man accused brutally started thrashing the deceased, and due to the injuries suffered, he died. The 2/8 of the prime convict appealed that they were not aware about the intention of the accused of inflicting such grave injuries on the deceased as it will cause his death. So, man accused in the case along with his two weights. So, there is man accused and there are two other persons holding the hands of the deceased and beating with hands and legs. They are holding the hands and they are beating with hands and legs. They are using their hands, they are using their legs and they are beating. After a while, when the man accused brutally started thrashing the deceased, and man accused brutally started thrashing him. And due to the injury suffered, he died. He died then and there. The two aides of the prime convict appealed that they were not aware about the intention. So aides said that the man accused has killed him, thrashed him brutally, but we were just holding hands. We were just holding hands and we were just harming him. We did not do brutal harm, but we also punched him and we also gave him fist blows and now blow by leg. So we also hit him, but it was mainly man accused who gave him brutal thrashing. So he should be held liable. We should not be held liable for section 302. So now again the question is section 302 read with 34. So if there is common intention, all will be charged. Now section 34 incorporates the principle of, now court says, man accused gave brutal assault. He assaulted brutally. And two aides holding hands of deceased and beating with hands and legs. All right? Now, this is the fact. Issue is, can we invoke section 34 against them and charge all for crime? Main question is this. Can we invoke section 34 against all three? That is the question. Now, let us address this issue. Can we invoke section 34 against all? Against all and charge all for that crime? That is the question. This is the question. Can we invoke section 34 against all three? Because that is the argument. Two aides are saying that we are not involved in the crime. You just understand this. Krishna Murthy versus State of Karnataka. Now, court said, court said, court said that section 34 incorporates the principle of shared intention. Shared intention, shared intention. That is common design between two perpetrators. Common design between two perpetrators. Perpetrators, all right. which make the second or other participant also an equal or joint perpetrator as the main or principal perpetrator, which makes, now see, this is the fundamental point, which makes the second or other participants also an equal or joint perpetrator as the main or principal perpetrator. Now it says accordingly, to attract applicability of section 34 IPC, the prosecution is under an obligation to establish that there existed a common intention before a person can be vicariously convicted for the criminal act of another. To attract applicability of section 34, the prosecution is under an obligation to establish that there existed a common intention before a person can be vicariously convicted for the criminal act of another. The ultimate act should be done in furtherance of common intention. Common intention requires a pre-arranged plan, which can be even formed at the spur of moment or simultaneously, just before or even during that act. So, it says to attract applicability of 34, prosecution is under an obligation to establish that there existed a common intention. That is what is the requirement of law. And then only you can charge them under section 34. And this common intention can develop even at the spot. I have already said, even at the spot. So this is a repetition, I am not going to repeat that. It can develop before the crime or even during that act, yes. Now another point which they say, they further said, they can be held liable under section 34 they can be held liable under section 34 if prosecution establishes common intention and this common intention can develop 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 just before or even during attack. They say further, for application of 34, it is not necessary that the plan should be made well before in time. Plans should be made well before time. Common intention can be formed just a minute before. Just a minute before itself. Very important observation and relevant observation. See, we have in section 34 written that criminal act should be done in furtherance of common intention. So there may be some situation where common intention, like I gave example, that common intention was to kill the father, but then they killed his PSO. So it is in furtherance, because it furthers that. But suppose you have gone to commit murder and somebody committed rape, it is in furtherance? No, it is out of way. Somebody has gone, the group has gone to commit murder, somebody committed theft. Is it in furtherance? No, no, not at all, not at all. So that is what is to be kept in mind. That is what is to be kept in mind. So be careful about this. Let us see further section 35, 36, 37, 38 also. Nothing big, section 35, 36, 37, 38. If you see in your material itself, page 89, 35, 36, 37. Now what section 35 says? Now you can look into section 35 in your Bear Act also, if you have Bear Act. You can see this in your Bear Act. Section 35, what it says. Just read it, don't worry. Section 35 says, when such an act is criminal by reason of its being done with a criminal knowledge or intention. Whenever an act which is criminal only by reason of its being done with a criminal knowledge or intention is done by several persons, which is criminal only by reason of its being done with a criminal knowledge or intention is done by several persons, each of such persons who joins in the act with such knowledge or intention is liable for the act in the same manner as if the act were done by him alone with that knowledge or intention. So act is criminal by reason of it being done with a criminal knowledge or intention. It is done by several persons. Several persons are already doing it. Each of such person who joins in the act. So whoever joins in the act, each of such persons who join the act with such a knowledge or intention is liable for the act in the same manner as if the act were done by him alone without his knowledge. So in section 34 on one end you said that the criminal act is done by several in furtherance of common intention of all. Here the fact is that an act which is criminal only by reason of is done by several. So act is done by several already. And then some person joins. Act is done by several first. Then some person joins. Then some person joins. And he joins with same knowledge. He joins with the same knowledge or intention. Some person joins with same knowledge or intention. Same knowledge or intention. Then what will be liability of this person? Then the liability of person joining will be similar as in section 34. So you are required to read nothing, you are required to understand only that here there is no common intention basically. I can't find the word common intention here. This is the only difference. You are doing an act, several persons are doing an act with criminal knowledge or intention, then some person joins it with same knowledge or intention. So there is no common intention, but the liability is same. So in section 35, even if there is no common intention, liability is same or similar. Liability is same or similar. Liability is same or similar. Can you see this? Liability is same or similar. Liability is same or similar. Liability is same or similar. Now see section 36. Section 34 is the only important section. These are just auxiliary sections. Just read it because you never know that the illustration of this section may be asked in the examination. Now section 36 is effect partly caused by act and effect partly by omission. So you can cause some action like see, I want to be an officer, I will concentrate on my studies and I will remove all distractions. So I'll do positive thing that I'll study hard, I'll study smart, I'll study with all concentration without any distraction. When I'll study, I'll concentrate on studies so that my mind works properly and I'm engaged totally in my studies. But there may be situation that there are other distractions. Your friends comes and they say that let us go to party and let us waste our time, let us go to see movies. No, let us gossip. So you avoid all this. So you can do a thing by adopting some positive methods and by removing the negative things. And that is how you can accomplish the object. So now section 36 in this regard says, whenever causing of a certain effect or an attempt to cause that effect by an act, positive act, or by an omission, so you omit certain things, I will not do this, I will not do this, is an offense. It is to be understood that the causing of that effect partly by an act and partly by an omission is the same offense. Causing of a certain effect or an attempt to cause that effect by an act or by an omission is an offense. So section 36 says, even if an offense is caused partly by even if an offense is caused partly by act even if an offense is caused partly by an act and partly by an omission, now even then, even if an offense is caused partly by an act and partly by an omission, it has the same effect. It has same effect. It doesn't matter at all. So now suppose I want to kill somebody, so I'll give him beating and I will omit to give him food, so he will die immediately, he'll die now very soon. So partly by act and partly by omission. In illustration say A intentionally causes death partly by illegally omitting to give food and partly by beating. A has committed murder. For example, you write in your own language, murder can be committed. Murder can be committed by partly giving him beating and partly omitting to give him food. Is this clear? Partly give him beating and partly give him food. Very simple. Section 37. Section 37. Cooperation by doing one of several acts constituting an offense. So cooperation is similar to the doing of criminal act. When an offense is committed by means of several acts, whoever intentionally cooperate in the commission of that offense by doing any of those acts, either singly or jointly with any other person, commits the offense. So, when an offense is committed when an offense is committed by several acts, when an offense is committed by several acts, then person intentionally cooperating when an offense is committed by several acts, then person intentionally cooperating in commission by doing any one of the act, by doing any one of the act. Singly or jointly. Either he does it singly or he does it with somebody else. Both, singly or jointly. When an offense is committed by several acts, then person intentionally cooperating in the commission by doing any one of the act, either singly or jointly, is liable for the offense. See, I have tried to simplify this language. An offense is committed by several acts. So several acts are involved in the commission of crime, obviously. Then person intentionally cooperating. I come and I cooperate to you. By doing any one of the act, either singly or jointly. I'm doing it at my time, you are doing it at your time, or we are doing collectively. In both cases, we are liable for the offense. Intentionally cooperating. So if I am intentionally cooperating, I am liable. If I am not intentionally cooperating, I am not liable. Section 37. Offense is being committed by several acts. One act is done by you and another act is done by me. And I am intentionally cooperating in commission of the doing of the act. Singly, let us say, I am also liable for the offense as you. You are jailer at your time and you want to kill somebody. And I am jailer in the same jail in the second shift. So there is some kind of agreement between you and me. So this is jointly, we are cooperating, intentional cooperation is there. That when you will be there, you will omit to give him food. And when I will be there, I will omit to give him food. Or I will deprive him of necessary medicines. So what is going to happen? He will be killed ultimately. So who are liable? Both you and me are liable for murder. Both. Both. Just try to, this is just for an example. I made you and me the point of example so that we can understand it very easily. Now see illustration A. A and B agree to murder Jack by severally and different times giving him a small dosage of poison. So you give him poison, I give him poison. At your time, you give him poison. A and B admits the poison according to the agreement with intent to murder Z. Nothing great. You and me agree to give poison to third party. That is what is written. Why to remember A, B, Z? It's all unnecessary. Z dies. The third party dies. Here A and B intentionally cooperate in the commission of murder and each one of them does an act by which death is caused. They are both guilty of offense. Though their acts are separate. We are doing it singly, separately. Now see section 37 second. A and B joint dealers as such have the charge of a prisoner, alternatively for 6 hours. A and B intending to cause judge knowingly cooperate in causing that effect by illegally omitting each during the time of his attendance to furnish Jed with the food supplied to them for that purpose. Jed died of hunger. Both A and B are guilty of murder of Jed. Yes, because there is intentional cooperation. Both are joint jailers. And as such have the charge of Jed, a prisoner, alternatively for 6 hours at a time. They have planned to cause death of Jed. Intentionally cooperate. Jed died of hunger. Illustration C. A jailer has the charge of Jed, a prisoner, intending to cause Jed's death. Intending to cause Jed's death. Illegally omits to supply Jed with food, in consequence of which Jed is much reduced in his strength. A jailer has the charge of Jed, a prisoner, A intending to cause Jed's death, illegally omits to supply Jed with food. Illegally omits to supply Jed with food, in consequence of which Jed is much reduced in his strength. But the starvation is not sufficient to cause death. Starvation, a jailer has come, he has omitted to supply food, and the victim, the prisoner, has reduced in strength, but it is not sufficient to for death. A is dismissed from his office. So there is no intentional cooperation. Try to understand. There is no intentional cooperation in illustration C. In illustration C, there is no intentional cooperation. Now A is dismissed, B succeeds. B without collusion cooperation with A illegally omits to supply Jed with food, knowing that he is likely thereby to cause death. So B will be held liable for causing murder, but A will not be held liable for causing murder because A's act did not result in death. Murder requires death. I will teach you later on, but murder requires death. So whether A's act resulted in death, A was dismissed. So at that time, if it would have stopped, there was no death. But B came and there is no collusion with A. So B now does the same thing and prisoner dies. So can A and B be held liable on the same ground? The answer is no, because there is no intentional cooperation between them. A's act is entirely separate, B's act is entirely separate. There is no collusion, cooperation between them. So A's act results into now attempt, but B's act results into murder. So see how it is written, B is guilty of an attempt to commit murder. A tried, but he could not succeed because he was dismissed from the job. This is what is attempt. This is what is attempt. So you can see in illustration A and B, both agree to murder. There is intentional cooperation. So liability is same, but in illustration C, there is no intentional cooperation. There is no intentional cooperation and acts are separate. So liability different. Liability different. Liability is different. This is very important example illustration C. This may be good question in examination. As there is no intentional cooperation, so no same liability. 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 No. See section 38. Person concerned in criminal act may be guilty of different offences. Where several persons are engaged or concerned in the commission of criminal act, they may be guilty of different offences by means of. And you just saw in illustration C of section 37. Several persons engaged. Several persons engaged in criminal act may be guilty of different offences. Several persons engaged in criminal act may be guilty of different offences. Several persons engaged in criminal act may be guilty of different offences. May be guilty of different offences. Several persons. We just saw in illustration C also, section 38. Several persons engaged in criminal act may be guilty of different offences. A attacks Jad under circumstances of grave provocation, that is, killing of Jad would be only culpable homicide, not amounting to murder. A attacks Jad. Alright. B having ill will towards Jad and intending to kill him. B has ill will towards Jad. A attacks Jad, B has ill will towards Jad. And intending to kill him. B has ill will towards Jad and intending to kill him and not having been subject to provocation assists A in killing. A attacks Jad under provocation, under grave provocation. Has ill will towards Jad and uh, intends to kill Jad and assists A and under no grave provocation. So B is not under grave provocation. So a person under grave provocation has benefit that his criminality will be little less. So A attacks Jad and even if A kills Jad, his liability will be little less because he is under grave provocation. Hot-blooded murder and cold-blooded murder. I'll teach you in section 300. Hot-blooded murder, you have certain exception. Cold-blooded murder, now you will not have exception. A attacks Jad under grave provocation. B has ill will towards Jad and intends to kill Jad. B is using this as now important opportunity for him that by A he can kill Jad. And what he does, he assists A in killing Jad. But he is under no provocation. He is under no provocation. He is under no provocation. Now question arises in such situation that what will be liability of A and B? What will be liability of A and B? That is a question. That is the question. What will be liability of A and B? What will be liability of A and B? That is the question. So I said, my dear friend, liability of A, liability of A will be for culpable homicide not amounting to murder because A will get exemption, exception. But liability of B will be for murder because there is no grave provocation to B. So different people in same case, there may be different consequences. And this is obviously so. Now you just understand by common sense example. I am speaking from my class, and many of you are listening across India. Somebody may be sitting in Kerala, somebody may be sitting in Jammu, somebody may be sitting in Nagaland, somebody may be sitting in Gujarat or Mumbai or Chennai, or whatever, or in Delhi or in Bihar or in Pune, wherever you think similar, no, Dehradun, whatever. The question arises that whether all are under same stage of learning. No, even if I am speaking the same thing, different minds will perceive it differently and they will learn differently because it cannot be same for all. So consequences of the same statement which I am making from here on different persons are different. On different persons are different. So how in that case it can be same. Now see, when I have taught you the section 34 to 38, let me check the questions now first, which I have covered today. Thank you very much. God bless you all.